Good afternoon, everyone, and welcome to WA Live Court TV edition. This is the last, final day, final case of this long week of Supreme Court week here at Woodward Academy. We are here at Gresham Chapel, and by now, I'm sure you all know the routine. You're going to hear the last case we have, which is called Fisher versus the University of Texas. The judges will process in, the students will argue the case before them, the judges will render a verdict, and in between time, we're cutting back and forth between the courtroom and here in the studio to give some color commentary. And in addition, as I promised to you earlier this week, we also have a special guest for you. Now, I have flanked to my left former ACLU attorney, Ms. Maggie Berthew, here as a color commentator here at Woodward Academy Court TV. And off to my right, I have former U.S. Attorney Mr. Bill Batterman, who will also be providing color commentary for this particular case. All right, now, counselors, let's talk about this case. As I understand it, this is a reverse discrimination case in which a white student is arguing that she was denied admission to the University of Texas solely because of her race.
That's absolutely right. Abigail Fisher, a white student, is arguing that she was denied admissions to the University of Texas because of her race, and that denial of admissions violates the Equal Protection Clause of the 14th Amendment.
Now, do you think the judges will rule the same?
I'm not sure. The issue for the court today is that they're going to need to clarify their previous rulings on the case, most recently in Grutter v. Bollinger, where they determined that the use of race in college admissions is legal, even under the 14th Amendment. So what they're going to be asked today is to determine whether the University of Texas system meets the standards that they set in that case, or whether they need to raise those standards.
Okay, now, as I understand it as well, there's normally we have 9 judges on the court. Today we're only going to have 8. Will you please explain why?
Absolutely. Justice Elena Kagan will not be with us today. She assisted the Justice Department in their support of the University of Texas in this case before she was a member of the court. So she has recused herself.
What does recuse actually mean for those of us who may not be steeped in legal jargon?
Absolutely. Justices or judges at the lower court level can recuse themselves when they believe that they have a conflict of interest, which just means that she's going to sit out the case, that it will be decided by 8 justices instead of 9, which means that the University of Texas probably has a harder job than they would otherwise. I think the best scenario for the University of Texas is a 4-4 decision, which would allow the Texas system to stand. But the other possibility is that it's a 5-3 decision for Ms. Fisher. And I think that the justices will all be looking today to Justice Kennedy as the swing vote in that determination of whether it's a 4-4 for Texas or a 5-3 for Fisher.
Okay, thank you very much. All right, now, Mr. Batterman, tell us, what are your perspective on the case, and explain for the audience, for those of them who are not steeped in legal jargon, what exactly does Ms. Berthew mean when she said that Kennedy may be the swing vote?
Okay, well, the issue at hand is whether the University of Texas's admission process fulfills the spirit of the Grutter v. Bollinger standard that was established in that case. And the way that their system works is that the first 80% of their grade in any given admissions class is the top 10% of high school students in Texas. And then the remaining 20%, they consider a wide range of factors. In Grutter v. Bollinger, the court ruled that institutions can consider race, but only as one of many criteria. The University of Texas thinks that they're following that standard. Now, Justice Kennedy, because he is the sort of swing vote in this instance, it means that he will probably issue the decision that decides the case. The 3 liberal justices that are deciding the case, so other than Kagan, will almost certainly side with Texas. They believe in affirmative action. Roberts, Scalia, and Alito will almost certainly side with... And Thomas will almost certainly side with the challenger because they don't believe in affirmative action. Kennedy has to decide, does he want to end affirmative action and say that race can't be considered, functionally overturning Grutter v. Bollinger, or does he want to allow the University of Texas system, perhaps clarifying the specific implementation of that system. So we will probably see the justices ask questions that are tailored to getting Kennedy on their side. We might see the counselors specifically target their arguments toward Justice Kennedy.
All right, final word from you. Who wins the case?
4-4, University of Texas stand.
All right, you heard that. Final word from you. Who wins the case?
I think 5-3 for Fisher.
5-3 for Fisher. All right. Now, you heard that from our esteemed color commentators. We have a 4-4 decision, but there's a 5-3 decision. We will actually see what the Supreme Court does based upon the arguments that the student lawyers are going to make. Now, remember, if you want to chat with us live during the proceedings, please go to todaysmeet.com/BKJ. So it'd be todaysmeet.com/BKJ. If you chat with me live, I will respond as soon as I possibly can. All right, now, without further ado, let's go straight back to the court for the proceedings, in which you will hear arguments that will be made in the final case we have for this week, which is Fisher versus University of Texas. Thank you very much for watching WA Live Court TV.
Supreme Court is now in session. The Honorable United States Supreme Court Justice presiding. The first case on the docket today is Fisher versus the University of Tennessee at Austin.
Okay. Is the attorney for Abigail Fisher present? Attorney for University of Texas present? Right. All right. The attorney for Abigail Fisher, you may approach the podium. Yes, sir.
There is a very complex process for admission to the University of Texas at Austin. There is a two-tier system for admission for freshman students who are residents of Texas. In the first tier, students are admitted under the top 10% law. The law mandates that a Texas high school senior who is in the top 10% of their class must be automatically admitted to any state university in Texas. Nearly 80% of the freshmen in 2008 were admitted under this law. The remaining applicants were admitted under the second tier. The second tier consists of the Academic Index, AI, and the Personal Achievement Index, the PAI. The AI was determined by the applicants' standardized test scores and their high school class ranking. The PAI was determined from 2 essays and a personal achievement score. This personal achievement score was determined by considering the applicant's leadership skills, work experience, awards, honors, community service, and applicant's special circumstances. These special circumstances consider the applicant's socioeconomic status, family responsibilities, and their standardized test scores in relation to their schools, as well as the applicant's race. By the law, the University of Texas must show that it is necessary to use in its admissions decision in order to further a compelling government interest, which it's not. The university seeks diversity only to obtain the level of diversity that is the same level as in the state of Texas. In order to reach this goal, the university has to establish a racial quotas, which is illegal based on the Bakke versus California decision. Also, in Grutter versus Bollinger, the use of critical mass is established. Critical mass has to have a number value.
Counselor, and define critical mass.
Critical mass is whatever, if someone says, have a critical mass of balls that land in this square instead of this square, it's saying that you do something until you've reached a percentage or number that they feel is enough for what they need.
Counselor, are you then asking this court to change its verdict from Groter versus Bollinger and say that critical masses are illegal?
Yes, that's one of mine.
Why do you think, what evidence is there that the University of Texas is able to reach a critical mass of minority representation in their student body with the top 10% law? Like, why is that? What evidence is there that is sufficient to achieve a critical mass?
When you have the top 10% law, it's the top 10% of every high school in Texas. And when you're trying to reach the diversity level of the state of Texas and you're taking from the top 10% of all the high schools in that state, it's basically acquiring the same diversity because you're taking from each school in that state that decide to go to Texas.
Since implementing the top 10% law, do you have, I'm not sure if the numbers exist, but in terms of how the racial representation has changed at the University of Texas in the ensuing years? Like, how has that helped in terms of this problem in achieving critical mass?
Based on the University of Texas, and Texas is in the state comparing it to itself, there's about 80% of Caucasians in Texas as in the state, and there's about 50% that are at the university itself. So the university is a little more diverse now than the state of Texas as it is. Yeah.
So does the court define critical mass based on a quota?
You can't really have a critical mass without a quota. You can't have a mass of something or a maximum versus a minimum without establishing an actual number, and a number is racial quotas.
Can you know that you haven't met the quota yet without haven't met the critical mass yet without establishing a quota?
It's determined. How are you going to determine critical mass in the first place? You have to have a number.
Would Miss Fisher have gotten into the university even if race were not a factor? Because it seems to me like if she didn't have the scores, then she wouldn't have gotten in anyway, and this seems like a moot issue then.
I think the whole problem was she wasn't worried about the top 10% law. That wasn't her goal. She realized that she's the top 12% in her class. She wasn't going to make the top 10%. But it's the fact that in the second tier, there were people less qualified than her that were admitted, that were Hispanic and African American.
And how do you know that?
It's just based on the statistics that were given to her.
What statistics were given to her and by whom that included the specific qualifications of other students who were admitted?
It was her denial from the University of Texas. Based on the people, she just knows that the University of Texas admitted less qualified people based on minorities.
She just knows. There's no actual release reports based on race and statistics from the school itself.
Not literally from the school itself, but I guess from hearing from other people and her friends and people that go to the University of Texas, there are less qualified people there than at
Who
her
makes
school.
the judgment that they are less qualified than Ms. Fisher?
I think it's
Ms. Fisher?
Yes. I guess. I guess it determines the school that you go to. If you go to a college preparatory school based on a public school, it's probably known to be better as a college prep student than a public school student.
Why didn't Ms. Fisher attend the University of Texas, switch to the University of Texas in next semester? That was an option that she had, and that she chose not to do it.
I think she wanted to get into college and get everything over with and be able to start getting us the job that she wanted and everything under control as an 18-year-old or a new freshman college student. And coming in the second semester, I think would have delayed a lot of things and sort of looked at it for job applications and everything to know that you got in second over first. It doesn't.
What is the majority race at your university?
The majority race is Caucasian. The diversity seeks can also easily come through the top percent law. That's another way they can reach their diversity. But in conclusion, my client and I asked the court to narrowly tailor, if not overturn, the decision of Greta versus Bollinger and see that the use of race in the university admissions process is racial quota and a violation of the Equal Protection Clause in the 14th Amendment.
Thank you. Attorney for University of Texas, you may approach the podium.
Thank you, Your Honor. To begin with, Abigail Fisher is a white, unsuccessful applicant to the University of Texas at Austin. She was denied admission to the university not because of her race, but because she was less qualified than the other applicants that we received. The plaintiff brought action to this case in April 2008, alleging that the university's undergraduate admissions policies violate the Equal Protection Clause and federal rights statutes included in the Fourth Amendment. University of Texas at Austin is a flagship institution of the Texas's public university system. It is a highly selective university, receiving approximately 4 times as many applications each year than it can enroll in its freshman's class. In order to enroll a diverse student body, the university continuously develops admissions process designed to identify the applicants who will bring the campus the attributes that the university values. In the admission process, the first tier is the 10% law, which states that any graduating senior in Texas high school is automatically accepted into the University of Texas at Austin. The second tier, which is the academic index, looks at the student's high school GPA and his or her class rank and standardized test scores. After that, the student is evaluated by PAI, which is the Personal Academic Achievement Index. PAI is a holistic review of applications to identify whose students' merit, class rank, or test scores do not adequately represent them in their applications.
Counselor, is there any evidence that students who had lower test scores or lower GPAs than Ms. Fisher were admitted to UT, to the University of Texas, who were Hispanic or Black or any minority race?
No, Your Honor. There were no students that were less qualified than Ms. Fisher that were allowed access.
Go ahead.
So what purpose does race serve in your admissions process if it is solely based on test scores and GPAs that you determine admission?
Can you restate the question?
What purpose does using race as a factor in your admissions decisions serve if the deciding factors are GPA and test scores?
University of Texas, they use race because diversity is a very key, is one of the values, is one of the most upheld values at the university. And we don't use a quota, which is illegal, but we do use a critical mass. And we know there's no specific definition of critical mass, but we know we have not reached it because University of Texas gives out a survey to minority students, and they still feel isolated. So it may not have a definition, but we know that University of Texas has not reached a critical mass.
So does this critical mass go on forever? And until when do you reach it?
You reach it when your students feel safe. Not safe, but they feel at home and they feel like they're not excluded because of their race. And so it wouldn't be like, well, there's 30% African American or 30% Hispanic, 30% Asian, or and then 30% Caucasian. It's just when your students feel at home and they feel as if they're not isolated from the other students.
Would race ever be a tie-breaking factor in the decision process? Because it seems like that would be problematic.
No, Your Honor. There's never a student that is exactly the same. So to say that there would be a tie it doesn't really work that way because no students have the same qualifications. Like there's always going to be a difference in the students, and whatever say they're the same, but there's one thing that they're different in. If that one student is different and better in that one thing, then we would accept that student because they didn't have the same, but they were very close, but that one student stood out more.
In this holistic approach that you're talking about, is race the highest in that category?
No, not at all. It's about 8% that we looked at it. PAI also focuses on two essays.
You said that race is about 8%. Does that mean there is a numerical percent value attached to the factor of the admissions process that race is?
Well, generally speaking, there's not a number. It's just like they just look at it. It's just
So how did you reach the percent that race is about 8% as far as the deciding factors are weighted?
well, there are multiple things that PIA focuses on. So if you do like the math, because it's not just like race and essays, there are also other things that go into that. So I mean, if you just kind of break it up, more of the essays are weighted more than race, and like the service to school and communication, in the community is weighted more. So it's just like.
So it's just a factor.
Yes, it's basically just a factor.
Okay, proceed.
So in Grutter versus Bollinger, they ruled in favor of Grutter because they use affirmative action. And so my client, University of Texas, it's basically the same as Grutter versus Bollinger, but we just want to keep our, University of Texas wants to keep their application process the same because they're not violating any, they're not doing anything illegal, they're not racially discriminating against any.
Why is the race a necessary factor in the second tier process when you're already getting some amount of diversity in the top 10% program?
With Texas, the majority of Texas high schools are predominantly white. So considering that fact that they're predominantly white, most of the students in the top 10%, which is what most students come to University of Texas on, is solely on the top 10%. Well, most of it, they're mostly Caucasian. So using race it just gives a little push to diversity because, like, most of the students that come are they're white, so Caucasian, so it just really gives a push. And
Counselor, to return to the case of Ms. Fisher, can you tell us the specifics of her, how she could have been admitted in the second semester as opposed to the first semester?
Yes, Your Honor. We accepted her under the condition that she comes in the second semester, and she could have, if she didn't want to, when on her senior year, she didn't want to have to take one more semester, she could have finished all her courses during that summer. So she could have been allowed access, but she chose not to take that pathway. Okay. And so basically, in conclusion, we just, my client, University of Texas, just wants to keep their application process the same and continue to use affirmative action because it just allows diversity to be an important factor, and that is what the University of Texas upholds. That's one of their most upheld values. So that's all.
Thank you. All right. Attorney for Abigail Fisher, do you wish to rebuttal? Okay. Give you 3 minutes. You may approach the podium.
I don't understand how someone can feel comfortable, I guess, at home when you have affirmative action, I guess, to make it equal in diversity or for races. I mean, we just came out of the civil rights movement, which was in the 1800s, and then the 1900s, too, with Martin Luther King and Rosa Parks. So there's still, like, people who have lived through those times who are still here. And, yes, there are always going to be those people who feel they're more dominant than other people, and it might be because of race. So, I mean, that's based on opinion.
But Counselor, don't you think there's a need for diversity on college campuses, college and university campuses?
I think there's a need for diversity, but I think that can be held by the students themselves.
But how can it be held? You said held by the students themselves?
They can be held accountable for diversity.
How can that be held by the students themselves if the students are not admitted to these colleges and universities?
If you're not admitted, I don't think that really has to do with diversity unless you're actually being racist, which is illegal. So that would be a different case. But if you choose to go apply to an all-white school and you're black, then that's your decision to go to an all-white school and you're black. Diversity doesn't really have to do with it.
Should the University of Texas not use race as a factor in the second tier in order to make sure that you're not applying to an all-white school so that the schools have more diversity to start with?
I don't think it's necessary in the University of Texas because you already have the top 2% law, and it's your decision. So what you decide is where you decide to go. I mean, if that's why you don't want to go to the University of Texas, because it's not diverse enough.
So are you saying affirmative action as a concept should be rejected, or only the further extent than the 10% rule?
I think the further extent should be accepted. Yeah, it's not really necessary. I mean, you're never going to walk into a perfect world where there's not racism or sexism.
So it's your position that diversity is not necessary?
It is necessary, but it's not necessary.
But how do you achieve that? How do you achieve? I'm trying to understand. How do you achieve that diversity?
Diversity you would have to achieve based on how you think or what your decision is. It's all based on an opinion.
But diversity is not about what the students themselves think, but rather whether or not they feel isolated in relation to other students of their ethnicity attending the same school as them. And the institution of the school decides which students are admitted. How is it therefore not the responsibility of the school to make sure that there's a sufficient amount of diversity to make each student feel as if they can apply to a school and that it is not just an all-white school?
I really think it just depends on the students. If it depends on the school, that's the school putting a number, basically a racial quotas, which is illegal. You can't set out a certain number of applications for minority students based on white students. You can't reach a critical mass without having a number. It's all racial quotas is what it comes down to.
All right. Thank you, Counselor. Thank you, both counselors. We will now take this matter under advisement. The United States Supreme Court is now adjourned.
All rise.
All right. I hope you enjoyed today's proceedings, and welcome back to WA Live Court TV Edition. Now, I told you earlier in the week we're going to have a special guest, and I am true to my promise. Please welcome to the WA Live studios, Miss Marsha Spiller. Miss Spiller? Welcome. Thank you very much for coming with us and seeing us today. All right. So here we have in Court TV Studios, we have the Vice President and Dean of Academic Affairs, Miss Marsha Spiller. All right. Vice President Spiller, thank you for taking time out of your day to spend a little bit of time with us here at WA Live Court TV.
It's my pleasure to be here. Thank you.
All right. Now, let's a little introduction. You're new to Woodward. You've been here for about a year or so.
Almost a year.
Almost a year. Yes. And in your former employment, you were the head of the children's school in Atlanta, correct?
That is correct. Yes.
All right. Well, how has your experience at Woodward Academy been?
I love being here. It's a wonderful place to work. I really enjoy all of the people here and the energy and the passion around education. And it's great to be in a K through 12 college preparatory situation that really allows me to have an impact on more students. So I'm really enjoying it.
Well, thank you. We are excited that you are here, and hopefully you're having a great time and you'll be here for a long time.
Thank you.
All right. Now, Vice President Spiller, I also understand that you were the former chair of the board of the NAIS, which is the National Association of Independent Schools. Will you tell us a little bit about your role and what the role of the NAIS is?
Well, as board chair, I oversaw 21 board members, and we're the policy-making organization for NAIS. And NAIS represents about 1,700 schools in the country and the world who are independent, and NAIS is the national organization that is the advocate for the independent voice of schools. So we support those schools help them follow their mission
Right.
and their purpose, and that's our role.
Okay, now you talked a little bit about the policy aspect of what the NIS does. It's my understanding that the NIS submitted an amicus for the court brief in the previous Grutter versus Bollinger case. Do you know anything about that by chance?
I do. I know that we have always supported welcoming and inclusive learning environments and have always believed that a diverse learning environment is going to be better for all of our students. And so we did support that decision.
Okay, and furthering that particular line of question regarding policy, what are some of the issues facing secondary schools regarding diversity education do you see today?
Well, I think it's very important that all students on all of our school campuses, in all of our schools, feel valued, honored, and respected.
Okay.
And NAIS does have a Welcoming Schools project that says that we want to be places that really do welcome all of our students and all of our families.
All right. Now, what is your personal opinion regarding the NIS or other members who support diverse education in America? What is your personal opinion regarding that issue?
Well, I believe also that diverse learning environments are better for everyone. I think that the more exposure that all of us have to lots of different kind of people and lots of different kinds of thinkers, that we're all going to be enriched by that experience. So I absolutely support the diversity in learning.
Speaking of that enriched experience and the diverse environment, you've heard the arguments by the students here today in front of the Supreme Court. Just briefly speak about what you learned and what your opinion was regarding their arguments.
Well, I was very impressed by the students and their research and what they knew about the cases. I thought that the two counselors did a very good job, and I thought the Supreme Court justices asked very tough questions.
Yes, they did.
And so it was clear to me that they knew the case and they knew the specifics of the case.
They were well prepared with it.
They were very well prepared.
Yes. I want to thank, to that end, I want to thank Mr. Bill Batterman and Ms. Maggie Berthume and their debate students who assisted in preparing the students for these particular debates.
They did a great job.
So this was a cross-curricular assignment that we had here today. All right, now let me turn attention to the actual case itself. All right, Vice President Spillard, you know we try to get Stephen Leslie, the provost of the University of Texas, to come here and talk with us at WA Live, and for whatever reason he declined, citing some pending legal litigation.
Too bad for him. He
Yes.
would have enjoyed being here.
Well, you know, we are happy that you are here instead. Now, so I would like for you to answer the questions in his stead. I'm going to ask you the questions that I would ask Provost Leslie if he were here today, which is, hypothetically, if the Supreme Court rules in favor of Ms. Fisher and states that the University of Texas may no longer use race as a factor in its admission process, how will you think a school such as the University of Texas or any other school for that matter be able to accomplish the goals of diversity education without regard to race as a factor in the admission process?
Well, I think it's going to be incumbent on colleges and universities then to find other policies or some other systematic approach to having a diverse population at their schools. If race cannot be used in the admissions process, then they will have to figure out a way to diversify their applicant pools in other ways.
Okay, now the exact same question, but let's say hypothetically the Supreme Court rules in favor of the University of Texas.
Then I think that is a message that says that, that a diverse learning environment is important, and that will make a statement that admitting students on race should not be required, but certainly if a school chooses to use race as one of the factors, that they can do so.
All right, very good. All right, now, as I understand it, we are now going to get the Supreme Court to come back in, and they're going to render their verdict. Now, I want to thank you very much for visiting with us here at WA Live Core TV version, and we're going to await the announcement of the verdict in this decision.
It's exciting. Thank you for having me.
Thank you very much.
The court spent some time deliberating of the arguments that were presented before the court today. It's a very difficult decision. There weren't any biased opinions made whatsoever, but the court hereby decides in favor 5-3 for the University of Texas. That concludes the business of the court. The court is now adjourned.